Hey everyone, and welcome back to The Explainer. Today we're looking at exactly what happens when the neat theoretical rules of a civil trial crash headfirst into messy, unpredictable reality. We're going to explore the nuts and bolts of trial procedure, how the courts react when things go completely off the rails, and, perhaps most interestingly, those shocking scenarios where legal professionals themselves are forced to open their own wallets to foot the bill.
To get there, we'll be following this roadmap. 1. Modes of civil trials. 2. Navigating the trial process. 3. The basics of court costs. And 4. When lawyers pay the price.
All right, let's kick things off with Section 1, Modes of Civil Trials, setting the stage.
So, under Order 33 Rule 1, civil actions don't just have a rigid, one-size-fits-all format. Now, while a trial by a judge alone is by far the most common setup you're going to see, there are other paths. Sometimes, a trial is handled by a registrar, who is a senior official of the court, though doing this requires either the specific leave of the court or the mutual consent of both parties. Alternatively, if a case is super technical, say involving really complex engineering or highly specialized medical knowledge, the trial might bring in an assessor. This is basically an expert brought in specifically to help the judge or registrar navigate those nuanced, highly specialized areas of the dispute.
Okay, moving right along to Section 2, Navigating the Trial Process, How it Should Work.
In theory, Order 35 lays out this beautifully logical, chronological back and forth. Step 1, the plaintiff opens their case and calls their evidence, which is, of course, subject to cross-examination. Step 2, the defendant does the exact same thing, opening their case and calling their witnesses. Step 3, the defendant delivers their closing speech, tying all those arguments together. And finally, Step 4, the plaintiff gets the very last word with their closing speech and reply. It's neat, it's fair, and it's totally orderly.
But as we all know, reality rarely respects a perfect sequence. So, what happens to this pristine timeline when the day of the trial actually arrives and one of the parties simply vanishes?
Well, under Order 35, failing to attend your own trial means you are proceeding at your own peril. If both parties fail to show up, the judge has the power to dismiss the action entirely, right then and there. But the rules do offer a little bit of a lifeline. A party has 14 days to apply to restore the case. To actually succeed there, they've got to prove an innocent mistake, like a genuine miscommunication about the trial dates, and, fair warning, they will very likely have to pay the costs incurred for the delay.
Now, if only the defendant is absent, it doesn't just mean an automatic default win for the plaintiff without a trial. The court still proceeds with the trial, meaning the judge actually sits and listens to the plaintiff's evidence before delivering a judgment. If the defendant later decides they want to set that judgment aside, they have a really strict 14-day window. But as we saw established in the case of Schacht and another, re Goldschmidt, they absolutely must prove a valid predominant reason for their absence. Just saying, oops, I forgot, isn't going to cut it here.
Let's jump into Section 3, The Basics of Court Costs, Who Pays the Bill?
The overarching principle here, which is firmly established in cases like Re Elgin Data Limited and codified right in Order 59, Rule 3, is that costs follow the event. In plain English, the loser pays. The unsuccessful party generally has to compensate the successful party for the expenses they racked up during the litigation. However, keep in mind this is always subject to the court's discretion. So, bad behavior by a winning party during the trial can sometimes mean they get way less than they asked for or literally nothing at all.
There's also a pretty stark contrast in how these costs are actually calculated. When costs are awarded on a standard basis, only reasonable costs are allowed, and any doubts the court has are resolved in favor of the paying party, which kinds of protects the loser from totally exorbitant bills. But if costs are awarded on an indemnity or solicitor-client basis, the tables completely turn. Here, any doubts are resolved in favor of the receiving party, meaning the winner is much more likely to recover the vast majority of their actual out-of-pocket legal expenses.
So, we know the losing party is usually the one footing this massive bill. But that raises a pretty fascinating question. What if the legal mess wasn't the client's fault at all? What if the lawyer is the one to blame?
Which brings us to our final section, Section 4, When Lawyers Pay the Price, Solicitor's Liability.
Under Order 59, Rule 6, the court has some pretty incredible power to penalize the solicitor directly. If costs are incurred improperly, without reasonable cause, or wasted by the solicitor's undue delay or misconduct, the court can actually step right in. They can disallow costs between the solicitor and their client. They can order the solicitor to repay their client. Or, and this is the most dramatic, they can force the solicitor to personally indemnify the opposing party. Now, importantly, the court does have to give the solicitor a reasonable opportunity to explain their actions before dropping this massive financial anvil on them. But how does a court actually decide if a lawyer crossed the line into misconduct?
Well, they use the test from the case of Francis versus Francis. They ask what a sensible solicitor sitting in his chair, considering what, in the light of his then knowledge, is reasonable in the interests of his client, would do. It's basically an objective standard of basic professional competence. So what actually happens when a lawyer fails this test in the real world? Let's look at a few examples.
Filing conspicuously unmaintainable lawsuits is a super fast track to personal liability. In Karpal Singh Vira Atip bin Ale, a civil suit was filed alleging defamation against a political party branch. The catch? That entity literally had no legal right to sue. The action was struck out, and the advocate was held personally liable for the costs. We see a similar thing in Mohd Yusuf bin Awang, where a lawyer sued on behalf of an undischarged bankrupt without getting the required legal sanction from the official assignee. By doing that, the lawyer breached their implied warranty of authority and, yep, you guessed it, had to pay the wasted costs straight out of their own pocket.
But you know, it's not always malicious. Sometimes it's just a totally tragic breakdown of facts. Just consider the timeline of the famous case Young v. Toynbee. On September 30th, a solicitor accepts a writ to defend a client. On October 8th, entirely unknown to the solicitor, the client is certified insane. Months later, on April 5th, the solicitor finally learns about this incapacity. Now, despite the solicitor acting in absolute good faith throughout that entire period, the court ruled they still breached their implied warranty of authority to act. The result? The solicitor was held personally liable to pay the plaintiff's costs right up to that date.
And if you think that's wild, consider the case of Simmons v. Liberal Opinion Ltd. In this one, a solicitor took steps to defend a newspaper company in a libel action. The only problem? The company hadn't actually been legally registered yet. They were literally non-existent at the time. Because the solicitor assumed authority for a ghost client, they were held personally liable to the opposing party for the costs. The massive takeaway here is that when you step into the courtroom as a lawyer, you are legally guaranteeing that you actually have a real client who has given you valid authority to speak for them.
Which brings us to the ultimate question for this explainer. We've seen the strict rules of trial, the incredibly heavy burden of court costs, and the absolute standard expected of legal professionals. But when procedural rules break down and totally innocent mistakes lead to such devastating consequences, does the pursuit of strict procedural justice justify the personal financial ruin of the advocate? It's a massive tension right at the heart of civil procedure, reminding us that the law isn't just a set of abstract rules on a page. It carries very real, very heavy human and financial stakes. Thanks for joining me today. Keep questioning the system and keep exploring the fascinating realities behind the rules.